you're sitting in your car, your heart is racing, there's shattered glass all over the ground, and you know you didn't cause the crash. But in the next few days, one mistake could derail your entire claim. The wrong word to an adjuster, skipping doctor's visits, or signing a release too early.
I'm Chris Blackburn.
And I'm Chad Romey.
Personal injury lawyers in Indiana, and we've helped thousands of people navigate these exact situations. In this video, we'll walk you through the claims process from crash site to compensation so you don't miss out on things like medical bills. Because once the insurance company starts asking questions, you need to know what to say and what not to say.
So right after the crash, what do? You're sitting there in your car, the accident has just happened. First thing, you're checking to make sure you and your passengers are okay. You're calling 911. You can check on the driver of the other vehicle, their passengers. First thing is make sure everybody's okay and get help on the way as soon as possible. Stay at the scene. A lot of people, we've talked about this before, there are people who flee the scene or leave the scene of an accident. Don't do that. All right. Even if the other driver and you say, look, it wasn't that big of a deal. Let's just trade some information and we can go our way. Do not leave the scene.
You're going to want to get the authorities there. So call 911 so that police report and the police officer can start investigating the crash immediately.
Yeah, while the evidence still exists, because if you leave the scene, that can be, in certain circumstances, a crime. And so you don't want to take a bad day and make it a whole lot worse by leaving the scene. Sometimes if you're in a really heavy traffic area, move your car to a safer spot. Before you do that, if you can, try to get as many photos as possible, both close up and far away, to document where those vehicles are, because in a case with disputed liability or disputed fault, that can be very, very important to get.
Even a simple video with your phone where you're walking around the entire exterior of your car and the other individual's car, it's going to be very good evidence. So you want to get those pictures and video not only of your car, but all the other cars as well. So if you're in a 5-vehicle chain reaction, try to get those pictures as long as you are physically able to do so.
Yeah. I personally prefer photographs. The videos have been helpful too. Photographs for me have just been easier to work with, but whatever you do, document what's going on, exchange information with the other driver, get their name, phone number, insurance company if you can, make and model of their vehicle, and license plate information as well.
Here's something that most Hoosiers are going to, I think, do quite well, and that's just be calm. You don't want to get angry or you don't want to start cussing at anybody, including the person who may have just caused the accident. That's something that could come up later on. Just be cool, calm, collective.
And you say most Hoosiers won't do that?
Well, maybe.
I've met some people. So
if they're Purdue fans, they're like.
So the key to the scene of the accident, when the police officer shows up, you're going to tell your version of the story. You're not going to be overly polite and apologize for an accident, certainly one that wasn't your fault. That can be used against you. You're going to stick to the facts and only the facts. The police officer will take all the information, eventually prepare a police report, and you can usually buy that online for a few bucks. And you can do that within 3 to 4 days, typically after the accident. That police report will contain names of witnesses, but sometimes it doesn't contain them all. So if there are witnesses at the scene, get their information. Don't assume a police officer is going to gather that. Those witness statements are very, very important.
A lot of our cases that we spend a lot of time fighting are the type of cases where our clients will say to us, well, yeah, there was lots of witnesses there, but the police officer didn't get their name and phone number and put those into the police report. So along with photographs, get names and phone numbers of witnesses.
And sometimes it seems to me like the police officer won't get the names of the witnesses when it seems clear what happened. Well, it was clear what happened when everybody was there. And then, gosh, stories start changing when everybody leaves the scene, and now all of a sudden you have a disputed case on your hands. So don't do that. After the accident, now you've left the scene. You need to report the claim to your insurance company. I usually start with your own insurance company, even in an accident that wasn't your fault. Your policy might require it.
Wait. But why would we do that?
Because your
It's not my fault.
Yeah,
Why
just
should
not your fault.
Why should my insurance company have to?
Well, you have that relationship with them, and most importantly, your contract might require you to do so. The last thing you want to do is void your own coverage, meaning where the insurance company says, well, gosh, you didn't jump through the right hoops after the accident, and so therefore you don't have coverage. You're calling them either that day or the next day, if possible. Tell them that you were in an accident. You're not going to talk about your injuries yet. You can tell them if you were injured, but you're not going to go into detail there. You're just going to say, hey, I was in an accident on Main Street. My car is now at the tow yard. And just in order to be able to set up the claims, you want to start that paper trail now.
It's really quite simple because when you buy insurance, you're paying for types of coverages. And so even though the accident wasn't your fault, you're still going to want to set up a claim with your own insurance company because there's some things in your policy that can be used to help you during a difficult time, especially if you're paying the yearly premiums on that.
So and that's the phone call you're going to make. But you might start getting phone calls too. And one of those phone calls might be from the other party's insurance company. And they're going, hey, we need your statement. We need you to tell us what happened. We need you to tell us about your injuries. You don't have to tell them about anything. You don't even have to take the call if you don't want to. You are not required to give a statement to them. They want you to, but it is not a requirement. So you're not bound by their insurance policy. Nothing in Indiana law requires you to jump through that hoop for them. You also might get a call, and this is a very niche thing. You might get a call from somebody who is either pretending to be an insurance company or just is straight out telling you, hey, you need to go to a particular medical provider. You want to be very careful about that as well. Doctors should not be cold calling you, or companies on behalf of doctors should not be cold calling you, trying to get you to go get their services. Go to your own family doctor if you need that. Yep. So we're not giving recorded statements to the other party. At some point, your insurance company is going to come out and inspect your vehicle, or the other insurance company is going to come out and inspect the vehicle. If there is a dispute as to who's at fault, I'd say you usually go through your own insurance company to get your property damage managed.
Yeah, absolutely. It just seems more often than not that our clients' own insurance company, they're gonna treat them better. They're gonna give them better service. They're gonna get their property damage, their cars either fixed or totaled out in a quicker fashion. Not always, but generally speaking, that's the better route to go.
Yeah, in the absolutely clear-cut cases of, gosh, I was sitting at a light, the other person was texting and driving and just totaled my vehicle. Or didn't total it and he's repaired. When you're dealing with a reputable insurance company on the other side, many times they will handle that property damage claim pretty rapidly, and then you wouldn't be required to pay your own deductible through your own insurance company. So remember, you got 2 years after your accident to get your case resolved or to file a lawsuit. So remember, you need to talk to your insurance company rapidly, and then you need to resolve the whole claim within the first 2 years, or again, file a lawsuit to preserve the claim.
Seems like a good point to talk a little bit about how the law works in Indiana. We have a modified comparative fault statute, and we can break that down into who's more at fault. And so, at least in Indiana, what we have to do is we have to establish that the defendants are more at fault than our own. So if you've got a disputed liability case where the insurance company is saying, hey, we've investigated this and we've determined that you're 20% at fault. What they're saying to you is that, well, we're just looking for a way to pay 20% less, okay? And in Indiana, you have the burden of proof to establish that the defendant is more at fault than you. And as long as you can do that 50% or more, you're going to win your case. However, if a jury were to find you a percentage at fault, whether it's 5 or 10 or 15, that's going to reduce your damages in the same proportion. So lots of cases out there, lots of accidents where the defense is looking for those types of things. And that's one of the main reasons you don't want to give a recorded statement, because you could say something that hurts your case and you had no idea.
Yeah, and you're saying something that, again, taken out of context, might put you at fault, when in reality That's not how the accident happened. That's just how your statement is being interpreted. One of those things that you can do is you can guess, if you're talking to the other insurance company, you can guess at measurements that happen in the accident, time, measurements of speed, measurements of distance. None of us are measuring those things within an accident. Usually accidents happen like that, but I've had clients tell me, or in a deposition say, gosh, I saw the other car come into the intersection, and then 10 seconds later, the accident happened. What they meant is it happened real fast, but they said 10 seconds. Gosh, you can stop your car and get out in 10 seconds.
And probably read a book.
Yeah. So it's, you want to be real careful with what you're saying to these insurance companies. Again, they're looking for reasons to try to discount the value of your claim. So,
real quick, I want to touch on this because it's a really interesting topic, and we hear it all the time. We hear people say it's not my fault, or I wasn't at fault. Fault's a big word, it's a buzzword. And the police report will, at least in Indiana, it'll usually put a primary cause. Our police report's been modified over the years, but insurance companies will use that police report to substantiate their argument that either our clients are at fault or you're at fault. But here's the truth. Police reports are inadmissible in a trial, okay? The cop can come and testify, but the cop can't render an opinion. So if you find yourself in a situation where insurance companies deny liability because the police report says you're at fault, that's where you're going to want to talk to a lawyer, because you probably have a case there and just might need some working for some different angles.
yeah. So I think an important point there is, if you know you ran the red light, if lots of times there just is an argument over who's more at fault for an accident. And that is the key, because in many, many accidents, it's not just one single cause. And so that's where a lawyer is going to be able to help you break it down. Okay, what's your chances of being able to prevail in that particular part of your claim? So after an accident, you've set up your claim, you figured out, you know what, accident wasn't my fault. How are you going to be dealing with your medical bills going forward? I need treatment. There's the way I talk about this with new clients is, first of all, when it comes to treatment, if you need it, go get it. Be open and honest with your doctors and follow doctor's orders. So meaning, if you need to go to the doctor, don't just grin and bear it. First of all, you need to treat in order to get better. But second of all, you need to treat in order to have the documentation to show the insurance company or the judge and the jury, this is what I was going through. So treat if you need to. Be open and honest with your doctor. And by open and honest, I mean, obviously you're not going to go in and exaggerate your injuries, but don't downplay them either just because you don't want to treat anymore. If you're treating for 6 months and you don't want to treat anymore, you're going to tell the doctor you're fine, so they don't prescribe any more physical therapy. But now that's part of your record saying you're fine when in fact you're not. And then finally, follow doctor's orders. It's your duty in Indiana to try to get better. It's common sense, but legally it is your duty to try to get better. And so follow doctor's orders.
I'll touch on real quick how your bills will be handled. So if you don't have health insurance, you're going to find yourself in a predicament, because the other person's insurance isn't going to pay for your treatment up front. You've got to prove your case. And once you prove it, then the insurance company will make you an offer for what they think is the fair value of the case, not what you think is fair. So if you don't have health insurance, it's going to be a little bit more difficult. If you do, you absolutely need to run all of your medical treatment through your health insurance. And we hear all the time, well, why should my health insurance have to pay? This guy's at fault. Again, they're not going to pay for those bills up front. You've got to go through your process. You've got to heal. You've got to treat, get better, and then you present it. And if we take that case all the way a trial is going to be 3, 4, 5 years down the road. You put yourself in a situation where, hey, I had health insurance. I should have used it. I did it. Now the bill's a lot higher. There's other avenues too. Your own automobile insurance may have some what we call med pay for short. And usually they'll pay it up to a certain amount. Once it's exhausted, it's done and over with. This is a separate topic, but generally, absolutely, if you've got health insurance, you need to use it.
Yeah,
for sure.
Yeah, it's not a matter of fairness. So it's not fair that I have to use. It's not fair that I'm using my health insurance. Well, okay, it might not be, but that's why you have your health insurance. That's why you have this. I tell my clients, treat all of your medical bills as if you got these injuries tripping down your own front steps. You would use your health insurance. So get the treatment you need. Don't ever sit on the sidelines not getting treatment just because you don't want to use your own health insurance. I had a client recently who she got in an accident, clearly not her fault for the accident, and she was doing what a lot of us do. She was sitting at home, grinning and bearing it for about 6 weeks. And finally she said, I can't do this anymore. I can't grin and bear it. And so then she went to start to treat. And the insurance company is looking at that 6-week gap in her treatment to say, you weren't hurt. When in reality, she was hurt. She just wasn't doing. And they have given a very low offer. Now that case is going to have to go into a lawsuit just because we can't get that insurance company to respond because of the big gap in treatment. It's a big thing over there in terms of how they evaluate claims and the claims they think they can deny or greatly reduce the value of. So once you go through all of your treatment, then we're talking about the settlement process.
Okay.
So
you're in a position where you can settle your case.
Yeah, you don't really. A lot of the clients say, "Well, why can't we settle my case? What's going on with my case?" Well, you're still treating. You're still treating, and you might have another 6 months of treatment. You don't want to settle your case typically during that time, because as you treat, gosh, first of all, we're going to know what your prognosis is or your physical health is going to look like going forward. And so as we go through that treatment and go through that healing process, the value of your claim continues to ebb and flow based on what your physical condition is.
This is a huge point. Once you settle, so if you were still treating and you settled your case, it's done.
You're done. Yeah.
It's over. You can't go back and say, hey, I'd like to reopen my case. Or, hey, I'm going to go see a doctor. I want to start my claim all over again. You can't do that. You're going to sign a release. The release is it's done. It's over with.
Yeah. So
let's talk about the different avenues of settlement, whether it's in a lawsuit or before a lawsuit. What's that look like?
Yeah. So most cases, a client comes in, and most cases are not catastrophic, right? So somebody might come in, might get an accident, have a few months of treatment, and then they get better, which is great. I tell all my clients, I hope you have a really, really small settlement. That seems weird. It's because you got better, right? The people who get large settlements have enormous injuries. And so most cases, there's a specific amount of treatment, it's done, and the person is better. And most of those cases are going to settle just with us calling the insurance company to negotiate. It doesn't require a lawsuit. It doesn't require a mediation or a trial. However, some cases can't get resolved, either because the insurance company is valuing it differently than what we do, or just because we've run out of time. We only have 2 years to settle that claim. And if I have a client who's treating for 3 years, gosh, the claim's not going to settle. And so most cases then that end up in a lawsuit or litigation will make it to a mediation, and mediation's successful 60 to 70 to 80% of the time.
Yeah.
Very few cases end up in front of a judge and a jury for multiple reasons, but most times cases are still going to settle even if you get into litigation. Lots of different things to go into the components of how they settle. What are the medical bills? What are the injuries? What's my lost earnings? What's my future lost earning capacity? So you might have an injury that takes you out of your career, and now you're changing careers. There's a lot of moving parts to these types of cases. I see sometimes online, I see settlement calculators.
Those worked.
I wish they did work. They don't work, right? So because there's so many different moving parts on what is my case worth, and these online settlement calculators will spit out a value, and they're just spitting out a value. It's not based on anything.
The law has changed a lot here in Indiana over even the last 15 years since I've been a lawyer. And I think there was a time where those settlement calculators might have been a little bit more reasonable. But now, because of the way that the bills work and who paid the bills and how much was written off and the liability concerns, there are so many moving parts.
Yeah.
So many different moving parts.
And frankly, just even where your accident happened.
So real estate's they say real estate. It's a big factor as well.
Yeah. So I think they say location.
Do they? I got that wrong.
They say it in real estate.
They say, yes,
they do.
Real estate.
They say that in location. All right. So when do you call an attorney? So not every accident doesn't require a lawyer. Right. So if you're just in a minor fender bender, you're not injured, they're not injured, you might call a lawyer for advice. Hey, what should I be doing? And we might give you advice, but we'll probably tell you don't need a lawyer for this one. It's when injuries get involved that I think that we can add value to the claim. And so, because it's, again, a lot more moving parts.
Yeah, absolutely. I don't think it's ever too early to call a lawyer in these situations, because a lot of lawyers are going to tell you it's not something I'm interested in. I can't help you, but they'll answer your questions. We've had multiple potential clients call us several times where we continue to give them free advice. And so what you're really doing is you're just arming yourself with knowledge and power and positioning yourself to be able to talk to an insurance company and play to it levels the playing field is really what it does.
I've told many folks, so there are people who are in an accident and then they think, well, should I hire a lawyer? Or sometimes they internally they say, I know I'm going to hire a lawyer eventually. When should I do it? If you're in that camp, you just do it.
Yeah.
Yeah, because the earlier you call us, the earlier we can start gathering evidence, the earlier we can start positioning your case with the insurance company.
Absolutely.
And most importantly, we are now the buffer between you and the insurance company. They don't get to call you anymore. They have to go through us. So they can't gather information from you that they can later use to try to
They're not
damage your
calling you and pestering you, sending you documents to sign which you have no idea what they are. That buffer can be very advantageous to a lot of people, and we have a lot of clients because they want that buffer. They don't want to deal with it, and that's the type of service that we set out to provide, where we can help
And
people.
personal injury lawyers in Indiana almost exclusively will operate on what are called contingency fees. So whether your case is valuable, not valuable, whether you can win your case or not win your case, if your case doesn't go well, meaning if a lawyer doesn't get you a result with a contingency fee arrangement, you don't pay that lawyer. Meaning if there's a $0 result, they get paid out of that zero.
Again, levels the playing field. It helps the little guy. The little guy can't afford a lawyer or a amount of lawyers to go fight on the insurance company and the insurance industry. So the contingency fee arrangement levels the playing field.
Yeah, absolutely. So to sum up, if you're in an accident, it's not your fault here in Indiana. The claims process starts with being safe and gathering the evidence while it still exists, right? Report the crash to the police, report the crash to your insurance company, and keep track of your medical care. Understand how fault works here in Indiana, and compensation. And don't be afraid to call an attorney if you hit a snag, or if you just want some questions answered, because there's lots of people are going through this for the first time. Call a lawyer, get some answers. You do not have to go through this alone.